Welcome to U.S. Immigration TV. Well, on May 27, 2021, the Biden administration issued a memo entitled Interim Guidance to OPLA Attorneys Regarding Civil Immigration Enforcement and Removal Policies and Priorities. Now, that memo could benefit so many people who are in deportation or removal proceedings, or they're concerned that they may be placed in deportation or removal proceedings in the future. What it does is gives immigration prosecutors more discretion on which cases they will pursue or even dismiss. In this video, I will go through that 13-page memo and I'll explain what it means, who may benefit, and how you may apply for benefits and how you could possibly take advantage of this memo right now while you're waiting for immigration reform. So be sure to watch this video until the end and make sure, of course, that you like, share, and subscribe to this channel to be kept updated on the breaking news and developments, as well as being kept informed on various other immigration matters. Now, basically, this memo instructs OPLA attorneys on how and when to exercise what is called prosecutorial discretion. Well, first of all, what is OPLA? OPLA means Office of the Principal Legal Advisor, which are basically the government attorneys who prosecute deportation or removal proceedings. You know, they're kind of like trial attorneys or prosecutors in the criminal courts. What is prosecutorial discretion? Well, according to this memo, prosecutorial discretion is the long-standing authority of an agency charged with enforcing the law to decide where to focus its resources and whether or how to enforce or not enforce the law against an individual. So let me give you an example of prosecutorial discretion. Let's say you have a jaywalker and a bank robber. Now, of course, both of them are breaking the law. And of course, the prosecutors should prosecute both. But I think society would feel uncomfortable if the resources were being spent on prosecuting jaywalkers while there's so many bank robbers going on. And in fact, in this particular case, there's like over 1.3 million cases in the immigration courts. So prosecutorial discretion is kind of like, there are a lot of people who are violating immigration laws and technically they could all be deported. But prosecutorial discretion says, you know, we're going to focus on the really bad guys. And if a person's immigration violation is not so bad, we're going to let it go. Now, under the Trump administration, virtually anyone who was out of status or kind of like violated any kind of immigration law was considered a threat to national security or public safety and was therefore subject to deportation or removal. Now, what this memo does is instructs OPLA attorneys to focus primarily on what is called, and I quote, enforcement and removal priority cases. And they should be more flexible and lenient with other types of cases. So, what are the enforcement and removal priority cases that the government is going to continue pursuing? According to the memo, there are 3 categories of cases that are, and I quote, presumed to be enforcement and removal priorities for ICE personnel. And the government should continue to prioritize their resources on removing people who fit in these categories. So what are the categories? Number 1, national security. Now, this includes non-citizens or aliens who have engaged in or are suspected of terrorism or espionage, spying, or are otherwise a threat to the national security of the U.S. Number 2, border security. Now, this includes non-citizens who were apprehended at the border or at a port of entry, like an airport, while attempting to unlawfully enter the U.S. on or after November 1st, 2020. And finally, number 3, public safety. Now, this includes non-citizens who have been convicted of an aggravated felony, and that's defined in the statute, or are members of a criminal street gang. Now, therefore, If a person fits in one of these three categories, the government's going to continue to pursue deportation or removal proceedings against them, as, of course, they're considered presumed to be enforcement priorities. Now, for other types of cases, ICE, Immigration and Customs Enforcement, and OPLA attorneys may consider whether or not to exercise prosecutorial discretion. And here are the sort of things that involve prosecutorial discretion. Deciding whether to assume custody of a non-citizen who is subject to a previously issued detainer. Now, a detainer is a notice to local law enforcement agencies that ICE wants to assume custody of a person who's about to be released from jail so they can be deported. Sort of they committed a crime, they are serving their sentence, they're about to be released. ICE wants them so they can be deported. Now, here's the next one, and this is important in terms of prosecutorial discretion. Deciding whether to issue, reissue, serve, file, or cancel a notice to appear, or NTA. Deciding whether to stop, question, or arrest a non-citizen for an administrative violation of the civil immigration laws. Deciding whether to detain or release a non-citizen from custody. Another one, which is also very important, deciding whether to settle, dismiss, oppose, or join in a motion on a case, or narrow the issues in dispute, or whether even to pursue an appeal in removal proceedings. Let's say, for example, the non-citizen won. Well, the OPLA attorneys sometimes appeal the case. Well, prosecutorial discretion can give them the discretion if they're going to appeal or let that decision be final. Another aspect of prosecutorial discretion is deciding whether to agree to administratively close or continue a case while the non-citizen pursues other forms of relief. Deciding when and under what circumstances to execute a final order of removal. And finally, deciding whether to grant deferred action or parole, which is basically an agreement not to deport or remove a person at the present time. This memo also lists the various factors that the OPLA should evaluate on whether or not to exercise prosecutorial discretion, and whether there are mitigating or favorable factors or aggravating or negative factors in deciding whether or not to exercise prosecutorial discretion. So, what are the mitigating or favorable factors when a person wants to seek prosecutorial discretion? And of course, when I list them, see how many may apply to you. One of them is length of residence in the U.S., military service, family or community ties in the U.S., the circumstances of the non-citizen's arrival in the U.S. and their manner of entry. For example, did they sneak across the border? Did they enter on a fraudulent visa? Things like that. Prior immigration history. The next one is current immigration status, especially when the person is already a lawful permanent resident or green card holder. They should be entitled to much more lenient treatment. Work history in the U.S., education in the U.S., a person's status as a victim, witness, or plaintiff in a civil or criminal proceeding, whether the person has potential immigration relief available, such as, for example, they just married a U.S. citizen who wants to petition them, or their child who's born in the U.S. just turned 21 and wants to petition them, contributions to the community, compelling humanitarian factors, including the person's poor health, age, pregnancy, status as a child, or, and this is important, status as a primary caregiver of a seriously ill relative in the U.S. Now, I know that there are many people who are right now caregivers to elderly or sickly people, and this would seem to be a very favorable factor because, after all, if they're deported or removed, who's going to take care of that person? Now, there are also several aggravating or negative factors where OPLA may not necessarily be willing to exercise prosecutorial discretion and perhaps will continue to go after the person for removal. So, what are those aggravating factors? They could include criminal history, participation in persecution of others or human rights violation, an examination of the extensiveness and seriousness of prior immigration violations, or if they have a lot of fraud or misrepresentation. Now, people who believe they may be eligible for prosecutorial discretion can request it from OPLA attorneys. Now, even if they don't request prosecutorial discretion, the OPLA attorneys should be examining their existing cases on their own and determine whether or not favorable exercise of discretion may be appropriate. In fact, I remember during the Obama administration, when prosecutorial discretion was in effect, I would have clients in removal proceedings, and the government attorneys would call me up asking if we would agree to have the case dismissed or closed. Yeah, of course. The OPLA attorneys could also join in motions to reopen or recalendar or motions for other forms of immigration relief. Well, that's how prosecutorial discretion can work. Yeah, a person can be deported, but because they are a low priority, the attorneys are willing to put it on the back burner. Now, if you are in deportation or removal proceedings, or if you were previously ordered removed, but you now have a way to apply for immigration benefits, let's say you married a U.S. citizen, and you're not one of those 3 enforcement priorities that I listed at the beginning of the video, I would strongly recommend that you consult with an attorney who can evaluate your case and immigration history and determine if you could be eligible for relief by way of seeking prosecutorial discretion, which could include reopening your case or even having it dismissed and things like that. Your attorney could negotiate with the OPLA attorneys or package your request for prosecutorial discretion, depending on the circumstances of your case. But I have to tell you, this is a breaking development, and it's great news for people, as it's a radical departure from the Trump administration, where practically everybody who had any immigration violation was considered an enforcement priority, and the government seemed to want to deport everyone who even had the most minor immigration violations. In fact, I saw one case where somebody applied for an extension of a visitor visa. They not only denied it, but they put him in deportation. Now, I hope you found this video informative, either for yourself or maybe for somebody you know. And we will continue to keep you updated on important immigration developments and news. So please make sure to like, share, and most importantly, press that subscribe button. I'm Michael Gurfinkel, and this is U.S. Immigration TV.